Hello, I'm attorney Vince Davis. Today, we are discussing the most significant changes to California's criminal justice system in a generation. As we navigate through 2024 and prepare for 2025, it's vital for defendants, families, and legal professionals to understand these new mandates and sentencing enhancements. The biggest shift comes from Proposition 36, the Homelessness, Drug Addiction, and Theft Reduction Act, which passed with overwhelming support in late 2024. This measure fundamentally rolls back key portions of the 2014 Proposition 47 reforms, increasing penalties for repeat offenders and specific drug crimes. Under the newly created Penal Code Section 666.1, petty theft or shoplifting involving property under $950 can now be charged as a felony wobbler. This reclassification triggers if the defendant has two or more prior convictions for theft-related offenses like burglary, robbery, or grand theft. What makes this particularly severe is that there is no time limit on these priors. Even a conviction from 20 years ago can be used to elevate a new charge. Drug possession laws are also shifting. Health and Safety Code Section 11395 introduces a treatment-mandated felony for possession of hard drugs like fentanyl or cocaine. If you have two prior drug-related convictions, you may face this felony charge. However, defendants can opt for mandated drug treatment to earn a dismissal. Courts are now required to issue the Watson advisement. This warning states that providing hard drugs resulting in death could lead to future murder prosecutions. Beyond Proposition 36, the California legislature has passed a comprehensive retail theft package that goes into effect on January 1st, 2025. Laws like AB 1802 and SB 982 have permanently codified the crime of organized retail theft, removing previous sunset clauses that would have seen these penalties expire. Prosecutors now have the power to aggregate the value of stolen property from multiple incidents within a 90-day window. If the total value across those 90 days exceeds $950, it can be charged as grand theft, exposing you to significantly harsher penalties. Additionally, AB 2943 makes the possession of over $950 worth of stolen goods with the intent to resell them a standalone felony. Courts can also issue retail theft restraining orders for up to 2 years. Violating these orders to enter specific stores can lead to further criminal charges. Sentencing for fentanyl trafficking has also been tiered by weight. The penalties for selling even small amounts have increased significantly under AB 701. Under Proposition 36, being armed with a firearm during a drug sale now mandates service in state prison, completely removing county jail as an option for sentencing. Procedurally, AB 791 now removes the option for post-conviction bail for anyone convicted of crimes punishable by life without the possibility of parole. On the side of fairness and reform, the Racial Justice Act continues to expand, prohibiting convictions or sentences based on race or national origin. Through AB 256, these protections are retroactive. Starting January 1st, 2025, eligibility expands to those with felony convictions entered after 2015. By January 2026, the Racial Justice Act will become fully retroactive, allowing anyone with a felony conviction to challenge it if racial bias was a factor. Also starting in 2025, prosecuting agencies must use race-blind charging procedures, redacting race information before a prosecutor makes the initial charging decision. In October 2025, AB 321 will grant judges expanded authority to reduce wobbler charges to misdemeanors at any point before a trial actually begins. Counties are also now required to hold post-conviction planning meetings to manage the high volume of cases triggered by these legislative reforms. Criteria for compassionate release have also broadened, providing more paths for release based on medical conditions, mental health, or age-related vulnerability. New domestic violence laws, like SB 989, emphasize the mandatory removal of firearms from individuals arrested for domestic abuse or subject to protective orders. These laws are intricate and their effective dates are spread across the next 2 years. Navigating this complexity requires a defense that is ahead of the curve. With nearly 40 years of experience practicing law in California, I have witnessed the system evolve, and I know how to fight for your rights under these new rules. My office is committed to staying at the forefront of these changes to provide you with the most effective representation possible in 2024 and 2025. Don't let these new laws catch you unprepared. Call us now at 888 6582. I'm Vince Davis, and we are all in this together.